We are set here today on a final trial on the petition to modify the underlying order. We were here back in October of 2025. The mother and father in this case were served to appear today, and they both have failed to appear. So therefore, we're going to move forward with the default in this case. Attorney, I have a question. Attorney Attorney
Yes.
Pacini, is there any objection to the state proceeding first as an intervener so
N-
that we can go ahead and dismiss her?
Yes, that's fine, Your Honor.
Okay. All right. State.
Thank you, Judge. The state is just requesting a judgment on arrears that Mr. Leach owes to Ms. Smith. The judgment date would be as of March 31st, 2026. There are only child support arrears owed, and for the total, it's $2,549.37. The state's requesting that it be paid back at $50 a month beginning May 1st, 2026.
Okay.
And that is the extent of what the state's requesting, Judge.
Buckle
All
up.
right.
Guys, today we are stepping inside a courtroom where things take a surprising turn right from the start. The judge opens a final trial expecting both parents to defend their case, but neither of them shows up. That silence speaks volumes. With no one to contest, the court moves forward by default. And just like that, the state steps in, demanding repayment of overdue child support, instantly raising the stakes.
All right. Thank you. The court will confirm the child support arrearages as of March 31st, 2026 in the amount of $2,549.37 to be paid at $50 a month beginning May 1st of 2026.
Thank you, Judge.
Thank you, Attorney Franklin.
All right, thank you. And I can send you the judgment language to include in there if that's easier.
Yeah, if you can.
Okay, I'll email it to you.
All right, thank you.
Thank you. Have a good day.
Thank you, too.
Thank you. Okay, Attorney Pacini, you may call your first witness.
All right. Ms. Green, can you state your name for the record?
Yes. Lillian Green.
And what is the child subject in this lawsuit's name?
Zaylee Leach Smith.
And has Zaylee Leach Smith resided with you the previous 6 months and 90 days to you filing this motion to intervene as a non-parent custodian?
Yes, correct. I took her home from the hospital.
And she has resided with you in Dallas County since she was brought home
Correct.
from the hospital.
Yes, correct.
And you've lived in Dallas County in Texas with Zaylee since, or for the preceding 6 months to you filing this motion, correct?
Yes, correct.
And you attached the affidavit that demonstrates the need for Zaylee to live with you due to the circumstances of the father being in and out of incarceration, as well as the mother not being able to meet the needs of the child, correct?
Yes, correct.
And subsequently, we had a temporary orders hearing in October, in which time the father appeared, but the mother did not appear, correct?
Yes, correct.
And the judge ordered that you were temporary sole managing conservator and that both parents would have possession of Zaylee. However, since then, the father has only made one phone call to her in the last 6 months.
Yes, correct.
Other than that, he has had no communication regarding seeing her or having any possession with her, correct?
Correct.
And same with the mother. The mother has not attempted to communicate with you or myself in order to facilitate any visitation, correct?
Correct.
And at this time, you're asking the court to adopt basically the temporary orders that were issued in terms of naming you sole managing conservator, both the biological parents as possessory conservators with the rights and duties outlined by the Texas Family Code, as well as providing you the same amount of child support that was ordered through the OAG under the temporary orders, correct?
Yes, correct.
And the same language for the health insurance will be covered again. Is that correct?
Yes, correct.
And do you have private insurance or do you have Medicaid for Zaylee?
Private insurance, and her mother or biological mother have her own Medicaid.
Okay. So you want the sole right to carry the insurance for Zaylee, correct?
Yes,
Because if she's not in possession, the mother shouldn't be able to apply for any benefits of Zaylee, correct?
correct.
And you believe that due to the circumstance that Zaylee's lived with you since she was born and that neither parent has adequately cared for her and basically abandoned her since
All right,
birth.
guys. Now the case takes a deeper and more serious turn. A guardian steps in and reveals that the child has been living with her since birth. What unfolds is troubling. One parent cycling in and out of incarceration, the other unable to meet basic needs. Even more striking is the lack of effort from both sides, with almost no contact over months. From an outside view, it begins to look less like hardship and more like abandonment.
Birth, that it's the best interest for the court to adopt you as a sole managing conservator with all the rights and duties,
Correct.
and that if any other or if the parents reach out, that you'd be okay doing those phases again to allow them to see their daughter.
Yes, correct.
All right, I pass the witness.
Okay, Attorney Pedicini, there is a possession and access in here for the phases for the father. Are you asking that mother's possession and access mirror that?
Yeah, I mean, if we can do other weekends, frankly speaking, I don't believe that in the last 6 months that they have done anything to see the child, that they would file an intervention or some other lawsuit which would handle their actual interest. So if we could maybe add, instead of, I know it was 2 hours you put earlier, correct?
Yes.
Maybe if we just do an hour each, would that be sufficient for you, Honor? And just cut it?
Yes, and the Saturdays, the Sundays and the Saturdays, they're a little lengthy, and
Yeah.
that was stepping them up. I don't
Okay.
think that's in the child's best interest because it's been so long.
Yeah.
If anything, I think um the court would do like a Saturday and Sunday, maybe the second and fourth Saturday and Sunday of each month, 10 to noon, to at least get it started. And then, after that 10 to noon and so many are satisfied, then they'll have to petition the court for anything more because it already covers electronic access.
Right. So
Um,
I apologize, Your Honor. I just
Yes.
had to grab a pen. I went dead. You
that's
said
okay.
Saturday and Sunday, first, third, and fifth from
No,
10.
the second and fourth.
Okay, second
Second
and
and fourth. I think first, third, and fifth is a bit
Two.
much.
Okay.
That was just temporary to kind of work up to this point. But since nothing has changed with that, I think the second and fourth,
Okay.
10 a.m. to noon will be sufficient right now.
Okay. And did you want to do 10 to 12 for dad, 12 to 2 for mom, or 10 to 11 for dad, 11 to 12 for mom?
Okay, so dads right now, we'll do 10 to noon for for dad. That's on the second and fourth.
Okay.
And then for mom, we can do first and third, 10 to noon.
Okay.
So that way, back to back, the child at least sees both parents.
And I said, we're not trying to stop them from having access, but it's just if they don't want it, we're not.
Correct. And I think there needs to be some reunification. If they want to petition the court at some point, I believe based on the testimony and the pleadings on file, it would be very disruptive. So just to kind of give them an opportunity to step it back up, and the electronic access is there. So if at any time they wanted to FaceTime, it's already in the order for them.
Okay.
It was something else I was going to add. And for right now, no holiday. It'll just be that 10 a.m. to noon.
Okay.
Okay.
Okay. And like I said, I'll put in the language that they would need to apply and show interest and get to where they need to get to. And, if they want to see the little girl more, they can work for it. So I appreciate that, Your Honor.
No problem. It was something else I thought we were gonna. Mm. And we're doing, so the child support for mom is going to remain the same?
Yes, because that was from the OAG at the temporary orders because they were receiving benefits. And so they said that 80 for, I believe it was 81 for mom, and then dad was doing 3 something. And there was calculations involved due to the parents having other children outside of this suit.
Okay, I see 61 for mom and 355 for dad.
Okay. And Ms. Green, would that accurately reflect, you believe, what money they make, in your personal opinion?
Yes, I think so.
Okay.
Okay, we have the reimbursement language. Okay, Attorney Pedicini, is there anything further?
Now things shift
No.
toward decisions that will shape the child's future. The court carefully debates visitation, but the long silence from both parents weighs heavily. Access is limited, structured, and clearly conditional. Financial responsibilities are confirmed, but the focus remains on stability. In the end, the judge rules in favor of the guardian, making it clear the child's best interest comes first. If you found this breakdown insightful, make sure to like, subscribe.
No, I will just add the language for the possession order, but everything else will remain basically the same. Okay. And
Yes,
can I,
the court, after the testimony and and the court took judicial notice of all pleadings on file, the court finds that it's in the best interest of the child to adopt the temporary order that has been on file with the court since November 7th of 2025 with the modifications to the possession and access schedule for both mom and dad.
all right. Thank you, Your Honor. I'll get that e-filed here today, hopefully.
Thank you. If you would also send it to Brittany,
Okay.
it would get to me much faster if you do it that way.
I will do that avenue then. All right.
Okay.
Thank you, Your Honor. We're
You-
excused.
Yes,
Thank you.
you're welcome. You all have a good day.
Thank you.